Mr. Clerk, will you call the next case, please?
Yes, Your Honor. Cars, LLC et al. v. Ronald Ogle et al.
And will there be more than one argument on this side?
No, Your Honor, just one.
What about this side? Okay, have you divided your time? Okay, what is your time?
10 minutes on the motion to dismiss,
And,
5 minutes on the merits issues.
okay. And your reserved time, sir?
Yes, Your Honor. If I may, I'd like to reserve 3 minutes for rebuttal, please.
Okay, go right ahead.
Good afternoon, Your Honors. May it please the Court. My name is Nicholas Rendino on behalf of the plaintiff's appellants. Reversible error. There are a few factual errors in the Court's rough guide that will serve as fodder for plaintiff's calls for reversal. Those are not my words. Those are the words of defendant's counsel when they saw the errors in the trial court's draft order. We are here because the trial court incorrectly dismissed our lawsuit, rejecting meritorious claims stemming from a broken land sale deal. Defendant's counsel themselves have stated that the trial court erred, and that appears to be why they've taken the extraordinary step of filing a motion to dismiss this appeal. They argue in their dismissal papers that the one satisfaction rule and the doctrine of res judicata transforms the settlement with the Ogle defendants into a final adjudication that bars the separate claims that were brought against the Webb defendants. They are incorrect, and they ask this court to ignore its own precedent and the plain language of the Uniform Contribution Among Tortfeasors Act. Their theory, if accepted, would upend decades of precedent and undermine the intent of the Tennessee General Assembly when it enacted the Uniform Contribution Among Tortfeasors Act in 1968, which explicitly permits an injured party to settle with one defendant without discharging liability as to the others. The legislature codified that principle in Tennessee Code Section 2911-105. Tellingly, the Webb defendant's motion omitted any reference to Section 105 and relied on cases from 1897, 1949, and 1961, which predate the Uniform Contribution Act. On reply, and faced with overwhelming authority undermining their position, they changed tack, and they argue that Section 11104E precludes further recovery because, they argue, a settlement constitutes a judgment. But this court expressly rejected that argument in Wade v. Baybars, which the Webb defendants cite in their reply at page 6. There, like here, this court considered whether a compromise settlement, which is approved by a court and satisfied by one joint tortfeasor, bars a subsequent suit against another joint tortfeasor. This court held that the statutory language of Section 104E refers to, quote, a recovery of judgment, which contemplates an adversary proceeding in contrast to a voluntary payment, and expressly held that Section 104E does not include a compromise settlement. This court stated, quote, it is true the order of the court, after approving and confirming the settlement, states that it is made the judgment of this court. However, we do not conceive this to be a recovery of judgment. Wade is dispositive. It directly refutes the defendant's arguments that a settlement is a recovery of judgment under Section 104E, and it mandates denial of the motion to dismiss this appeal. A compromise settlement simply is not a recovery of judgment. But regardless of Wade, the settlement simply returned one parcel of property. It did not resolve the broader allegations of harm that are alleged. At most, the value of the settlement might later reduce a damages award, but it is not a full satisfaction of judgment, which involves separate and distinct claims that were brought against the Webbs, that were very distinct from the claims brought against the Ogles. Second, res judicata does not apply. There has been no prior adjudication between the plaintiffs and the Webb defendants, and crucially, the Webbs and the Ogles are not privies under Tennessee law. They were co-defendants accused of acting in concert, but each was sued for their own conduct under distinct claims. Defendants argue on reply that none of the authorities on which appellants rely in their response address the issue of whether privity exists between alleged co-conspirators for purposes of res judicata, but that is incorrect. Cruz v. Benin considered exactly such a scenario, and the court nevertheless held that, quote, release of one tortfeasor does not constitute the release of all tortfeasors. And as to the Webb defendant's claim that all co-conspirators are in privity, that is also incorrect, and it has been squarely addressed by the Tennessee Supreme Court in Knox 10 Rental v. Jenkins, which we cite in our brief at pages 10 through 11. The court there stated clearly, quote, the fact that he, Jenkins, engaged in these fraudulent acts through a conspiracy with Charles Cott does not alter his liability to the plaintiff any more than does the release entered into between Cart and the plaintiff. Defendants simply misstate the law. Their motion to dismiss should therefore be denied. I'd like to turn now to the merits of the appeal. This case centers on a purchase option that Rocky Top exercised under 2 land leases. The key issue is whether the transaction was wrongly terminated by the Webb defendants. The trial court dismissed our entire contract claim by accepting the appellee's argument that Rocky Top breached the agreements by not closing on the sale on April 1st of 2024. That ruling was incorrect because it misconstrued the contract language and it decided fact-intensive issues that should be resolved on the merits and not on the pleadings. As an initial matter, the Webb defendants fundamentally misunderstand the nature of an option. An option to purchase real estate, once exercised, creates a new contract for the purchase and sale of the property. The question of breach for missing the closing date thus concerns the resulting contract of sale. It does not concern the validity of the options exercised, which, as the Webb defendants stipulated below, were validly exercised. Tennessee's Supreme Court affirmed this principle in Chapman, and therefore any alleged failure to close on the proposed closing date does not terminate the option. It is a question of breach of the resulting purchase contract. But even under the defendant's proposed analytical framework, their arguments still fail because there was no requirement that the closing occur on the proposed date. The option agreements required Rocky Top to give notice of a proposed date on which it intends to close, and Rocky Top did exactly that. In June of 2023, it exercised the option and specified a target closing date of, quote, on or around April 1st, subject to extension, if necessary, to accomplish the closing. This wording is critical, and it makes clear that the parties contemplated flexibility in scheduling the closing. The trial court initially agreed with our interpretation of the agreements and stated, 1, that the agreements did not require a fixed closing date, 2, that the plaintiff's own exercise notice did not specify that the closing had to occur on April 1st, and 3, that the agreements did not provide for termination of Rocky Top's purchase option if the closing date was missed. But months later, in a complete reversal, the trial court, on its own initiative and without any additional briefing, concluded that, quote, the closing had to have occurred on April 1st. This was error. But even if it were true that the agreements required that the closing had to occur on April 1st in order for the option to be exercised, the trial court nonetheless erred because whether Rocky Top breached is an issue of fact that is improper for resolution at the motion to dismiss stage. And more importantly, plaintiffs pleaded that the parties mutually agreed to extend the closing to May 1st. Plaintiffs established that multiple writings evidenced the agreed extension. Tellingly, although the Webb defendants improperly dispute this evidence, they failed to address the case law establishing that whether emails satisfy the statute of frauds is a factual question that cannot be resolved on a motion to dismiss. Moreover, oral agreements can also modify real estate contracts where the modification concerns only the terms of performance, such as a closing date. The Webb defendants failed to address the case law holding that such questions are an issue for the trier of fact. Similarly, plaintiffs sufficiently alleged that the doctrine of equitable estoppel prohibits the Webb defendants from repudiating their promise to extend the closing date to May 1st, regardless of the statute of frauds. The Webb defendants argue that estoppel had to be affirmatively pleaded as account, but that is incorrect. A plaintiff is not required to preemptively plead around affirmative defenses. They also make a number of factual arguments about why estoppel should not apply, but whether estoppel applies is an issue of fact for the jury or the judge to decide. Plaintiff's brief also established that nothing in the agreements gave sellers a right to terminate the purchase if the closing did not occur on April 1st, and demonstrated that under Tennessee's law of material breach, a delay of closing cannot justify termination. The Webb defendant's brief ignores this argument entirely. They do not address A&P Excavating or this court's holding in Tatum v. Worsham. They also failed to address this court's opinion in Cants v. Bell, which held that the inability of a party to close on a particular date is not a material breach unless the contract expressly states that, quote, time was of the essence as it pertained to the closing date. The contracts here contain no such language. They similarly failed to address Cry-like Realtors v. Hay, which noted that for time to be of the essence as to the closing date, the contracts must explicitly state not only that the contract was to be closed on or before the closing date, but also that failure to close, quote, gives the seller the right to declare the contract canceled, end quote. Neither circumstance is present here. Plaintiffs also cite numerous cases establishing that the Webb's conduct violates the duty of good faith and fair dealing. The Webb defendants failed to address a single one, and they failed to respond to Regions Bank versus Thomas, which holds that the question of whether a party acted in good faith is a question of fact. And let me briefly address our other causes of action, the tort and equitable claims that the trial court dismissed alongside the contract claims. The trial court admitted that it did not address these claims, noting, quote, that all the remaining claims hinge solely on the existence of a legal contract. But as we noted in our reply, not all of plaintiffs' claims rise and fall with the breach of the contract claims, and that's specified in our reply at page 24. And finally, although this court need not consider the trial court's draft order on this de novo review, the trial court's decision to revise its draft order at the defendant's urging, combined with its act of striking the draft order from the record and its comments at the February 24th hearing, raised legitimate concerns about whether the trial court properly exercised its independent judgment in the manner required by the Tennessee Constitution. It is telling that the Webb Defendants Counsel told the judge that the trial court's findings and conclusions were, quote, leading this court into reversible error. Finally, I'll briefly address the defendant's cross-appeal. In short, the cross-appeal is meritless and indeed frivolous. The trial judge correctly denied the disqualification motion, and for good reason. There was no evidence of any impropriety. In fact, this very court has already considered and rejected the same allegations in Dover v. Dover, holding that the allegations are no more than, quote, speculation and insinuation. The trial court, this court, the Sevierville District Attorney's Office, the Sevierville Police Department have all looked at these allegations and found them to be baseless, but the defendants persist in leveling baseless accusations. Tennessee law permits the court to award damages for a frivolous appeal, and we submit that this cross-appeal fits that description. In closing, the appellants respectfully request that this court reverse the trial court's dismissal of the complaint and deny the cross-appeal. I see that my time's up, but I'm happy to answer any questions, Your Honors.
I hear none. You have your rebuttal time left.
Thank you very much.
Yes, sir.
Please, the court, Edward Pratt on behalf of the appellees. I'm here to argue the motion to dismiss that came to light after the trial court dismissed the case, and we were on appeal in the briefing schedule, and there was a settlement with one of the defendants in the case. According to this court's opinion in Norris versus East Tennessee Children's Hospital, a 2005 opinion, a final judgment is a final judgment, and it's entitled to res judicata effect where applicable. This motion is about the sanctity and dignity of final judgments in Tennessee, that once a court, here this court, enters a final non-appealable judgment, it must be given preclusive effect according to the dignity afforded all final judgments in Tennessee. Here we have the August 13th, 2025 order from this court that is entitled to the same enforcement and dignity of other final orders under the state law. Two preclusive effects are afforded this court's August 13th, 2025 order under the one satisfaction rule and as res judicata based on the allegations set forth in the complaint. Under the one satisfaction rule, where a plaintiff can recover multiple judgments against joint tortfeasors, it can have but one satisfaction of one of those judgments. That is stated in the common law, Shonley versus Nashville Speedway in 1961, Tennessee Supreme Court case, when the Uniform Contribution Among Tortfeasors Act was enacted 7 years later. That was codified in Section 104E of, it's 2911-104E. It's a codification of the common law rule that you can have multiple judgments entered against joint tortfeasors, but you can only have one satisfaction.
And the point of that is so that you don't have double recovery for the same injury.
Well, not necessarily. It's not really about what the plaintiff recovers in terms of making themselves whole. It's about if you just decide to go in multiple avenues to recover multiple judgments, then you have an election to make. And you may get more recovery in one, you may get a better target defendant or a creditor in another, and so you make an election, and once you've made that election, then the Contribution Act comes into play to help to spread that.
But in
cost.
this case, we're talking about, well, with different parties, we're talking about a settlement with the Ogles, and we still have other parties here that have been sued. And we're also talking about a parcel of property that is still being claimed, that was wrongfully sold.
And the problem is they went to judgment. And they satisfied that judgment.
And so they certainly can't get another judgment against the Ogles as to that piece of property that was transferred back to them.
They can't get a judgment against joint tortfeasors and have it satisfied, other joint tortfeasors. They can't get a judgment against the Webb defendants and then satisfy that because they've already had one satisfaction as to the joint tortfeasors in this case. Because the property was transferred, the closing occurred, the release was given, and the order of dismissal.
In the release, did it not specifically say this does not affect the remaining claims against the remaining defendants?
It does, and the fact that there's
So that's just superfluous?
It's superfluous, it's irrelevant. The fact that there's a settlement agreement, the fact that there's a release being given, if that's all that had happened, we wouldn't be here. This motion would not have been filed. The only reason it's been filed is that there is a judgment that was entered and it was subsequently satisfied, or was satisfied virtually at the same time. The appellant cited to Wade v. Baird, that's the one case that has interpreted this codification of the one satisfaction rule. And that was a situation where the plaintiff was a minor. And pre-suit, the plaintiff settled with one of the joint tortfeasors. And because it was a minor, the statute required that there had to be court approval. And so the attorney for the other joint tortfeasor then moved under the one satisfaction rule. And the court says, no, this was not an adjudication. This was not an adversary proceeding. This is simply required by statute so that we can further the interests of minors by making sure they're protected when a judge looks at it and blesses it. So it did not constitute a judgment on which the one satisfaction rule would apply. So, and in fact, when you look at what actually happened here, the motion that was filed to dismiss the appeal as to the Ogles sets forth in detail that it was pursuant to plaintiff's request and the plaintiff's settlement agreement between them and Mrs. Ogle. And that's in their motion itself. And that had, when the court entered that order on August 13th of 2025, it had preclusive effect two different ways. One, it constituted a consent judgment, which in Tennessee, a consent judgment is given res judicata preclusive effect. And as well, it had the effect, because the appeal was dismissed, because under Trap 15A, any dismissal is automatically with prejudice, it had the effect of affirming the trial court's dismissal that there was no actionable claim. So we have a final judgment that affirms the trial court in this action, yet we're here seeking an inconsistent result, reversing that and proceeding against the Webbs on the same theories. So, and there's no question here that the plaintiffs have been satisfied, and the test is not full recovery for the plaintiff, it's satisfaction of the judgment, not satisfaction of the claim. Res judicata is the other ground. They've conceded, there are four elements to res judicata. The one issue that is not conceded is that the judgments, the two judgments are between the parties or their privies. And the case of Anderson v. Rayner, it's a 2005 Court of Appeals decision, is instructive here. It's right on point. there were multiple defendants sued on a conspiracy claim, just as they have been in this case. And a motion for summary judgment was filed by two of the conspirators. The trial court granted the dismissal and certified it as final for 54.02 purposes. No appeal was taken. Later in the case, the remaining co-conspirators, alleged co-conspirators, moved for dismissal on res judicata grounds, and the trial court granted that, and the Court of Appeals upheld that. That's precisely what we have here. The allegations in this complaint was this common scheme or artifice that constituted a civil conspiracy amongst all the defendants. And they've settled with two of them and gotten a final judgment that's non-appealable for two reasons. One is a consent judgment. The other, it's an affirmation of the trial court's findings that there was no conspiracy. And now we, as the remaining defendants under Anderson v. Raynor, are moving under res judicata to dismiss, because this is a clear civil conspiracy allegation complaint, and two of the defendants are out, and there's a finding that the trial court's dismissal is affirmed as to them, and as the remaining defendants, we are seeking to enforce res judicata, because under that case, it says alleged co-conspirators are in privity with one another for res judicata purposes. So Anderson v. Raynor is right on point in this situation. And because we are in privity with the Ogles in the alleged conspiracy, we are entitled to the res judicata effect of the final judgment that affirmed the trial court, holding that there was no civil conspiracy, holding that all the actions have been precluded. They cite to the Uniform Contribution Among Tortfeasors Act under Section 105, changing the common law that you can release one joint tortfeasor and it doesn't have the common law effect of releasing all the other joint tortfeasors. That's not the issue. We don't take any issue with the fact that a release was given. The only issue that we're here on is the fact that the settlement agreement, the release, then became a final judgment. And so once it became a final judgment, that's a whole different concept. The fact that there's a release and a settlement agreement is not the issue. We wouldn't be here again if that had been the issue that had been brought before us. Policy considerations were advanced. One, we have a non-appealable determination that the trial court's dismissal as to the Ogle defendants was proper on a finding that there's no civil conspiracy. Now they want to have an inconsistent result by having this court reverse remand based on a finding that there was a civil conspiracy actually stated, and those would be completely inconsistent results.
The judgment, though, affirming the settlement with the Ogles make a finding that there was no civil conspiracy, or is it just a typical settlement agreement followed by order of dismissal?
The effect of, under Rule 15A, Trap 15A, to dismiss the appeal is to affirm the trial court. The trial court made the finding that the complaint failed to state a claim for civil conspiracy.
Okay.
And then they had other ways to resolve this without having a judgment. The fact that we have a judgment is a problem here and is preclusive to the rest of the appeal.
Okay.
Thank you.
Thank you, sir. Yes, sir.
Good afternoon, Your Honors. Nick Deagle here with Baker Donaldson for the appellees as well. It's a pleasure to be before you today. Regarding the merits of the appeal, the issue before the court is very simple. After neglecting to pay earnest money and sign purchase-sale agreements extending a closing date, should equity save appellant Rocky Top and bind the parties absent consideration to a purported oral contract extending a closing date?
Okay, if it's simple, why did it take you all 70-plus pages to brief this case?
That's fair
That's
point,
me
Your Honor.
just joking with you. It's fine.
Our answer to this hypothetical is absolutely not. Facing dismissal, plaintiffs for the first time in this case raised equitable estoppel in their response to our motions to dismiss. However, equitable estoppel is the exception, not the rule. It is only applied in the most extraordinary of cases. As the trial court correctly held, this was not an extraordinary case. The statute of frauds is a bedrock principle of Tennessee law. Anyone that's at least went to now the Winston School of Law and took Contracts 1, Statute of Frauds was taught your first semester in law school. Certain types of contracts have to be in writing to be memorialized. The complaint in this case alleges an oral contract, and because it involves the purchase of real estate, it must be in writing. The complaint in this case, the appellants alleged to escape the statute of frauds that there was equitable estoppel. However, the complaint is bereft of any allegations supporting this extraordinary exception to the statute of frauds. And to the extent there are allegations, they do not rise to the level that make it an instrument of hardship verging on actual fraud. That's a
Okay, but
well-established
the plaintiffs
standard.
are saying, how can we can't raise equitable estoppel until you raise statute of frauds as a defense?
Your Honor, it's their obligation. Tennessee law clearly states the obligation is on the party seeking to avail themselves of equitable estoppel to allege adequate facts. And I've got two cases on that. They're in our brief, but it's Powers versus Snow and Pittman versus Holland. And then we have a federal case, LeBlanc versus Bank of America.
And I think they would say, well, we did raise the facts, we just didn't necessarily call it equitable estoppel.
Well, the facts that they allege are inadequate as a matter of law to meet the standard. And I'll get to that shortly, Your Honor. For starters, going back to LeBlanc versus Bank of America, the Western District of Tennessee, although it's not binding on this court, it is persuasive authority. The court found that since it requires verging on actual fraud, that Rule 9 is implicated and specificity must be made in the equitable estoppel factual allegations. Those are not present here. The meager allegations in the complaint fail to demonstrate this is an extraordinary case, let alone a Rule 9 pleaded case. Instead, the pleadings established that there was no vigilance or diligence by Rocky Top. The trial court said it best earlier this year. All Rocky Top had to do was sign the purchase sale agreements circulated by the defendants prior to the April 1, 2024 closing date. The parties to these agreements are sophisticated businesses. Rocky Top is a car dealership. It has, I'm sure, sold thousands of cars over the years to customers with binding contracts. The parties were each represented by independent legal counsel negotiating an arm's length deal. As recognized by the Court of Appeals, disposal of equitable estoppel on a Rule 12 posture is totally appropriate. The pleadings in this case fail to support estoppel. In addition, the remaining tort claims also fail. Plaintiff's fraud claim is likewise not complicit with Rule 9 of Tennessee Rules of Civil Procedure, and then even so, the fraud claim alleged only regards a $24,000 Phase 2 environmental report, so it's just a microcosm of the case. Turning to the tortious interference claims, there is no improper motive or improper means to support those claims. There cannot be improper means because there is no breach of contract. Defendant's conduct was squarely within the bedrock freedom of contract principles recognized by Tennessee law and public policies underlying competitors' privilege, including a principle that private parties operating for profit maintain considerable discretion to refuse to enter into or continue a business relationship. And that's what happened in this case. That's what's alleged, is that the contract was either breached or they did it to punish the plaintiff for trying to negotiate a lower purchase price. Classic freedom of contract.
Do you agree, Mr. Deagle, that the plaintiffs did in fact exercise the option under the contract by sending, I think they sent one written notice, and I'm not 100% sure with respect to maybe the Whaley property, how that got exercised. But in any event, they seemed to at least have exercised both options, and then everything got sideways.
Well, Your Honor, it comes down to the question of whether they specified the proposed closing date. So
They specified a proposed closing date.
well, they've taken a position that it's on or around April 1st. We would
Right.
say that on or around is not specified. It is a range. It is an area of the calendar. It is not a specific date.
What do you think proposed means in the context of this contract?
I think the parties could pick I think that Rocky Top could propose a closing date, and they could change it up until the time that the appraisal was reached. That happened in February of 24. At that point, the contract says the closing date must occur upon the finding of or determination of a fee appraised value, whatever the term is.
It says it can't occur before the appraisal, right?
Well, it'd be impossible because we wouldn't know what the
Right.
purchase price was.
That just makes sense.
Right.
Okay.
My time's up. Do your honors have any further questions? Thank you.
Thank you. Your rebuttal.
Thank you, Your Honors. I will try to be brief. So I'm going to start with Mr. Pratt's argument about the motion to dismiss. Section 105 of the Uniform Contribution Among Tortfeasors Act makes clear the Tennessee General Assembly's intent. They intended to give parties the ability to settle with one defendant without releasing claims against all defendants. If the court were to accept the appellant's position, a plaintiff would be forced to choose between settling with one wrongdoer and forfeiting any chance of recovering from the others, or foregoing a partial settlement in order to preserve claims against remaining defendants. That rule would not be workable. What would plaintiffs do?
What about their argument? They say, well, there's another part of that statute that says, unless there's, I'm paraphrasing because I don't have it in front of me, but they're saying the fact that there was an actual judgment in this case is what makes it different. And what you're free to settle with people, but when you have it reduced to a judgment, that makes it different.
Of course, Your Honor. I would say two things in response. First is Wade v. Baybars addresses this situation squarely and says that 104E does not apply the judgment interpretation that they are urging this court to adopt. This court has already decided this issue and made clear that a compromise settlement does not fall within the scope of 104E. That's the first thing. The second thing, and equally as important, is that only some of the claims were settled here. We have another piece of property. We have other independent claims that were brought. For instance, we have a breach of contract claim. The breach of contract claim is brought only against the Webb defendants. It had nothing to do with the Ogles. So the first three counts of our complaint are alleged only against the Webb defendants. So why should they get a free pass because the Ogles decided to settle the case and return the land that my clients were entitled to?
And I guess he might say that it's the conspiracy because there was a conspiracy alleged.
Sure, and they make that argument, but Knox 10 Rental addresses that squarely. The court was very clear that in the context of a conspiracy, there's no res judicata effect of the conspirators' participation. Knox 10 Rental said very clearly that the fact that Jenkins participated in a conspiracy with Cart and was released did not, in fact, release Cart from the claims. And so that's important. They just ignore that case, and it's important to note that. I'll turn now just briefly to some of the things that Mr. Deagle said on the appeal. He said we didn't pay earnest money and that we didn't do due diligence. Those are fact issues. He can't make that determination, and neither could the trial court on a motion to dismiss where everything has to be interpreted in our favor. He also talks about the business relationships case of Watson's Carpets. Watson's Carpet does not apply here because that case was limited solely to the circumstances in which there was an existing business relationship, whereas there's none here. So we talk about this in the brief. We distinguish that case quite clearly, and I think it's worth just taking a look at that distinguishing. But I see that my time is up unless your honors have any further questions.
Okay. Yes, I don't hear any.
Thank you.
Thank you. Thank you both for your presentation. Case now has been submitted for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you very much again. You both may be excused. Thank you. Mr. Clerk, will you recess?